My name is Dave Philippone. I'm a partner here at Udin Associates. What I'd like to talk about with you today is the adjudication process at the Workers' Compensation Board. An individual who files a claim for a work injury at some point in every claim receives what's called a notice of decision. That decision can come in the form of what's called an administrative decision, a conciliation decision, a proposed decision, a decision from a hearing before a workers' compensation law judge. An injured worker has a certain amount of time to object to an administrative decision, a proposed decision, a conciliation decision. And if you fail to meet that deadline to object, you could be bound by the findings in that decision. So if you receive a document like that in the mail that sets forth a timetable to file an objection, you should immediately consult with counsel that's skilled in workers' compensation to make certain those findings are in fact appropriate and correct. Because oftentimes our office receives those on behalf of clients on matters we've been retained, and we routinely object because there's a mistake. So please don't sit on your mail. Please make certain you review those decisions. If you go to a hearing and a judge makes a ruling, each side is given 30 days to file an appeal of that decision. If you appeal the judge's ruling timely using the appropriate forms, you will then receive a board panel decision. Board panel decisions are issued by 3 commissioners of the Workers' Compensation Board. The Compensation Board consists of 13 commissioners, one of which is a chairperson and 12 other commissioners. When an appeal is filed from a local judge, the file is assigned to a panel of 3 and they issue a decision. Once that decision is issued by the 3-member panel, you have the right to simultaneously request that the full board review the decision if you don't like it, and request that the Appellate Division 3rd Department review the administrative body's decision. In New York State, any appeal of a full board or 3-member panel decision goes to the Appellate Division 3rd Department, which is the second highest judicial court in New York. And think of it this way. There's an administrative court that renders a decision, and if you get to the top of that food chain in that administrative court and are still unhappy with the outcome, you have the right to ask the judicial courts to review the administrative body's decision by going to the Appellate Division 3rd Department. And if you receive an unfavorable decision from the Appellate Division 3rd Department, you can then go, if the law permits, to the Court of Appeals and request relief. Not every decision from the Appellate Division 3rd Department is accepted by the Court of Appeals for review. And if you're at that stage in litigation and you're still seeking an appeal, you certainly by that juncture should have counsel.